Good day to everyone. In this video, we will be looking into the concept of winding up of companies and also the different types of winding up and the conditions that are to be followed under winding up of companies. So basically, first we will start with what do you mean by winding up of a particular organization. The word winding up can also be called as liquidation of companies. So winding up of a company means to liquidate an existing company or termination of the legal existence of a company that is already running into the market. Now there might be different circumstances to which a company might get liquidated. It might get liquidated because it is financially unsound. It might get liquidated because of the clashes with the management and the shareholder. It might liquidate because of the dues that the company has to pay because to its creditors, and there are various several other reasons why a particular organization winds up or liquidates itself. So, in simple, winding up is a process where a company tries to close down itself in order to from the legal existence of a company. Now, hope if you're a commerce student, the meaning of a company says that a company is that which has a perpetual succession. So that perpetual succession is where we are going to stop in case of winding up of a company by closing the existence that is legal existence of a particular company by following the proper procedures as per the Companies Act 2013. So under such circumstances, the assets of the companies are said to be disposed of and the debts are to be fully paid out of the amount that gets realized from the assets or from the contributors made by the members. And the surplus, if there is any surplus left out after paying to these, after paying debts and liabilities, if any, will be distributed among the members of the company. First, it will be paid to the preference shareholders, and then if there is any surplus available, it will go to the equity shareholders of the company. So this is the process of winding up, where in case of a legal winding up, a person called as a liquidator will be appointed by the court in order to realize the value of all the assets that the company has in order to pay the liabilities held by the company. Now with that, we will move on with the different types or modes of winding up. So through what all way a company can liquidate itself? Firstly, the company can compulsorily wind up by the court. Secondly, the company can go for voluntary liquidation or voluntary winding up, under which we have members voluntary winding up and creditors voluntary winding up. And the third type or the third mode of winding up or liquidation is voluntary liquidation under the supervision of the court. So we'll try and understand what do you mean by a compulsory winding up of an organization. So a compulsory winding up of an organization takes place when a company is directly winded up by the court order that is being provided. Now it depends upon what kind of scenario the company falls under and which court gives you a legal action. But any legal action provided by the court will be based on the grounds that are being stated under Companies Act 2013. The common grounds on which a company can be compulsorily winded up by the court order is when a special resolution resolved is passed that resolved that the company is to be wounded up by the court. And the second scenario is if there is any default is made in the delivery of statutory report of the registrar of companies. The third scenario where the company can voluntarily liquidate by the court is if a company does not commence its business within a year from its incorporation and the whole year it just keeps quiet without functioning or without any commerce activity that has been happening, then the company can be wounded up by the court. So the moment you register a particular company, the duration given to you from the date of giving you license is 1 year. So within 1 year of your existence, you should show some kind of sales or some kinds of activity that has been happening in the company. So if any company does not show any kind of progress, within a year of its incorporation, the court has all rights under the Companies Act 2013 to wind up the company because it has not contributed anything to the people or to the public, or neither has it given employment, etc. The next ground on which a company can liquidate itself by the court is if the number of members fall below 7 in case of a public company or below 2 in case of a private company. As you would have, if you're a commerce student, you would have learned that in business, we learn that in business management, we learn the minimum number of members that you require in order to get a company to be formed. So if you're forming a public limited company, then the minimum number of members that you require is 7. And if you're forming a private company, and then the minimum number of members that you require is 2. So in some cases, after the existence of the company, if the minimum number of members in case of public company or a private company falls below to 7 or 2, then the court can take a legal action of winding up of the company. The next scenario is if the company is unable to pay its debts. Let's say the company has taken credits from the creditors or from the suppliers, etc. And if it's not been able to pay its debts on time, and even after the frequent notice from the debtors or from the suppliers, then the court has all rights to liquidate or wind up the company. And the next scenario where the court can take an action for winding up of a company is when the opinion that it is just and equitable that the company should be wound up. So since we've understood compulsory winding up, we will move on to the next concept called voluntary winding up. So as we have seen earlier, a company can be voluntarily liquidated either by the members of the company or by the creditors of the company. The creditors of the company can also call for a voluntary winding up when they're not able to receive the amount. So that is a scenario where you say that the company is not able to pay its debts. So even after frequent reminders and notices sent by the creditors, if the company is not being able to pay the debts, the creditors have all rights to call upon a voluntary winding up in order to realize all the assets and take back the debts that they owe, that the company owes to pay them. So in case of voluntary winding up, a company can be wounded up voluntarily under different scenarios or circumstances. First one is by passing an ordinary resolution. Now, where the duration of the company was fixed by the article and the period has expired, in that case, an ordinary resolution can be passed in order to voluntarily liquidate the company. The second scenario is where the articles have provided for winding up on the occurrence of any event and the specified event has not occurred, then the company can call upon a voluntary winding up. The second major scenario is where a special resolution is being passed by the members or by the creditors in order to liquidate the company is when a resolution is passed by the members. In all other cases for voluntary winding up, it must be notified to the public by an advertisement in the official gazetted signature and as well as in the newspaper that such company is going to be winded up because of such circumstances and certain reasons. So this has to be brought to the notice of the general public, whether directly related or indirectly related. It is the duty or responsibility of the members of the company to bring it to the notice of each and every public by giving an advertisement in the newspaper and thereby passing a resolution for voluntary winding up. The third type of winding up is voluntary winding up under the supervision of the court. At any time after a company has passed a resolution for winding up, the court makes an order that the voluntary winding up shall continue, but subject to such supervision of the court and with certain liberty for creditors, contributors, or others to apply to the court, and generally on such terms and conditions as the court thinks that it is justified, the court can call upon a voluntary winding up. So hope in this video you would have got a gist on what is winding up or what is called as liquidation and what are the different grounds on which a company can call for a liquidation or winding up, where we have seen voluntary liquidation by the court, members voluntary liquidation, creditors voluntary liquidation, and voluntary liquidation under the supervision of the court. Thank you for watching.